It's on now.
There we go.
There you go.
Okay. A little, just 5 minutes, and then I'll take questions because I don't have a long presentation. JAMS was founded in California in 1979 by Warren Knight, who was a judge in Orange County. And from that, we have grown to have 25 offices around the U.S. We have 300 neutrals, and we do call them neutrals because that's the tenet of our whole company. And we do arbitration and mediation and special master work on all kinds of cases. We have never taken a position on policy. The things that you do, this is your job. And after sitting through the first 2 panels, I don't envy you. We just do what it is that you finally decide we can do. And we do it as well as we can, utilizing, I think, the best panel of people in the country. We've never filed an amicus brief in a case in 25 years, the 25 years I've been doing this, because to be neutral is really a tough thing. If you file an amicus brief, you're necessarily taking a position against somebody who is probably also a client, because all of the top law firms are clients and use JAMS. We have 50,000 lawyers a year that walk through our offices, and we just feel that the easiest and best position for us to take is one of total neutrality. We never lobby for or against arbitration. If you want to ban arbitration in consumer cases, you'll never see us standing up here and saying, no, that's unfair. We just don't do that. So with that, I think that there were a lot of questions raised in the first 2 panels that I just want to comment on. The standard that we have used are the minimum standards of fairness in both consumer cases and employment cases. And I'll hand these out, but you're not going to read them. But they are the basis of what we do. And in those standards of fairness, a lot of the things that were mentioned by Ms. Gilbride are forbidden by us. We will not take a case unless there's reciprocity, unless it is in the consumer's home county, unless the consumer or employee only pays a filing fee, which is similar to what they pay in court. There has to be reciprocity of remedies. People said that there was a prohibition against punitives. There aren't a prohibition against punitives. If punitives are allowed in the jurisdiction in which the arbitration takes place, then the arbitrator can grant punitives. We view arbitration as just a change in forum, not a device that a company can get a benefit, can change the law, can change what is applicable to the consumer or the employee. So these standards of fairness, you know, it's interesting. We talked about how clauses have changed. Yeah, clauses have changed because people saw that we wouldn't take cases, and then AAA adopted things similar. We won't take the case, so if you want either AAA or JAMS to handle the case, you got to abide by these. And if you don't, then, you know, you'll go to court and get an individual arbitrator appointed who has no standards of fairness similar to these, and we'll follow state law. And state law often permits a lot more than is permitted by our standards of fairness. So the venue issue is going to be in the county in which the consumer lives. And the interesting thing is, you know, about 50% of the consumer cases that are being filed at JAMS are being filed by the consumer. People think that all of the cases are cases company against consumer, but I was very surprised to find that a large percentage of cases are being filed by the consumer. So with that, for us, the consumer business, the mandatory consumer and employment business is a very small part of what we do. And as far as the ethics are concerned, we certainly strive to do the best job we can. We recruit the best. 70% of the new people we recruit are ex-judges, state and federal. So we try to get the best. We don't take them all. We really go after the best possible ones that we can. We train them in arbitration and that's part of what I do. And let me tell you, take a federal judge off the bench and try to tell him what to do. But that's what I do. And so we train them. We have a lot of training programs. We have a JAMS Institute, which is headed by Rich Burke, who was a professor at Willamette, who ran their ADR center up there, and he joined us last year after Jay Fulberg retired, who was the former dean at USF. And we have the JAMS Institute, which is only internal training. That's all. We don't train outside. We train in foreign jurisdictions. I'm going to New York tomorrow to go to Cairo to do a training for Egyptian judges. And so, we do a lot of training, and we have an ethics code, and we take it very seriously, and any complaints that we hear about or smell come to the Office of the General Counsel, which is my office, and we look into them. We take it seriously. So with that, I would love to answer. I'd love to ask, but I can't. I'd love to answer any questions that you might have.
Thank you. I've been sort of hogging the microphone, so anybody have any? Senator Wieckowski.
I had a little bill a couple of years ago about posting information that was sortable and so that we could independently, and we can have other universities to see how well JAMS is doing and how AAA. And as we looked at these, you do have it now in Excel sheets.
Yeah.
You have all the little bits, all the little categories.
All the little bits.
But it seems like a lot of them are left blank.
Yeah.
Yeah, so that's really hard for the...
How much does the employee make? They decline to answer. Can't force them to answer. We ask them every piece of information. Do you know how many people looked at the JAMS form last year? All of the trouble, time and money to comply with that. I think less, what? I think less than 2,000. And many of them, most of them are professors. The lawyers don't look at it because they know already who the people are, who they want or don't want. It's no big surprise. Whether it's a JAMS, Judicate West, AAA, they know who they want. So it's people who are trying to sort through things. And, if on another day, maybe we could have another meeting and talk about how we could make that, I think, more valuable and less daunting than it is, because I think it could be a value. We report everything. And
It seems one of the other problems that we have is that, the National Arbitration and Mediation, the Judicate West, the Resolution Remedies, and the Office of Independent Administrators, who are competitors with you, don't. They just they don't have anything in Excel. They don't have categories. They just we pass these laws because we care about, perhaps a miscarriage of justice, and we're asking, well, prove to us or show us, give us some data that we know that things are being administered fairly. So that's a frustrating.
I got a tough enough time at JAMS without speaking for the other people.
Okay.
Senator Allen?
Well, some of the folks in the plaintiffs' bar have been making the case that this is just an unfair system. I mean, do you believe these cases? Do you believe arbitration to be patently unfair?
I don't take a position on that. I do it, and we provide the... I understand. You're asking me for a personal opinion, and I'm not going to give it. I represent a company, and we do arbitration in accordance with the law in the best way possible.
You're a former judge?
No, no.
Okay.
I mean, I'm sorry, but you're asking me whether I think arbitration is fair. The arbitrations that we do, I think are, yes.
Okay. Okay, I understand you're in a delicate situation. I understand you don't do legislative advocacy. And I won't press you further.
Okay, thank you.
You know, I understand, we are looking for some guidance here because, you know, there have been a lot of reports, and I think many of us were very distressed in reading the New York Times report about what seemed like an incredibly unfair system. It was, many of us, I think, were really deeply offended and angered by what seems like the closing of the justice system and the opening of a system of kind of unjust and sort of biased and just, you know, unconscionable redirecting of a system that we all are greatly proud of, and part of what makes this country so extraordinary and our judicial system so extraordinary. So that, you know, I'm sure you understand what we are looking for some guidance here because we are the policymakers.
Yes,
and
absolutely.
To the extent that that there is value to the arbitration system, and I think there is. But I think also that so much of what makes our system work is the perception, is the public's perception and confidence and trust in the system.
I'm sorry.
No, and so I think that's kind of what we're looking for from you is some thoughts on that.
I will, but I just wanted to, there were two cases cited in the New York Times article, both of which were JAMS cases, both of which were absolutely incorrect, these statistics. In the one case, it was an employment case, and I feel compelled to to be very brief. The arbitrator had 8 cases additional after the start of the arbitration. Each of them was brought to the attention of both sides who were represented by counsel, and nobody objected. That's the system that we use. They informed them of the additional case, nobody objected. Then there was a case involving an arbitrator who they said had 40 cases, or some number of cases. And I'm going to tell you who it was, because it was one of your colleagues, Terry Friedman, and you tell me whether you think he's a stinko arbitrator or not. That case went to court first. The judge ordered it back to arbitration. Nothing we could do. Both sets of lawyers came in because there were a lot of individual cases, and they agreed to set the cases in bundles with a number of arbitrators. Terry got 40 of them, 34 were settled, and 6 were tried. He tried 6 of those cases. So that was a situation where the lawyers got together and decided how they were going to handle the situation and did it. A couple of suggestions, I just needed to, because you see articles all the time, and, you know, it's a lot of times the facts are not what they're stated to be.
None of us has ever experienced that.
No, I'm sure you haven't. I think what the struggle is separating the whole class action issue from the issue of how a consumer can best handle a complaint, handle an issue. Because I think if you separate them, then maybe we can all make some sense of this. Because the whole class action issue is a battle, is an economic battle, a battle between plaintiff lawyers and companies. And, you know, that will continue on, and Cliff is one of the supreme advocates of that and has been battling in those fields for a long time. But the issue of how do you handle small complaints if, as it stands today, there is no class action permitted. It's difficult, and I don't envy you. One alternative is to say, look, we have the right to send any case in arbitration to small claims court. Small claims court, go there. Don't come here. If you could think about how to raise the limit on small claims court in consumer matters to give consumers a place to go, because people think that all of these cases are collection cases, are companies suing consumers to collect debt. Which, by the way, to the extent they are, I can remember as a young lawyer being in court when they used to go to court and get default judgments, boom, boom, boom. Nobody went and said, you know, Judge, you're granting 99% of the cases in favor of the company. Because 99% of the time, the person bought the television and hasn't paid for it, you know, and the company is trying to find a way to collect. So fooling with the small claims limit and giving people a place to go that's easy to go to and inexpensive and no lawyers. The other is talk to business when you get a business about why they have arbitration, other than, as Cliff said, suppression of claims. Why they have arbitration clauses in contracts where you think most of them are going to be collection. And the reason I finally found a logical reason, the reason I was given by somebody representing businesses is because in arbitration, an employee of the company who is not a lawyer can represent the company in that process. In the California courts, you can't have an employee represent a corporation unless they're a lawyer. The president of the company cannot go improper on behalf of the company unless he or she's a lawyer. It's kind of crazy. You know, I mean, I don't think, and originally it was put in to help lawyers, but I don't think it does it anymore, because if companies could have claims administrators handling these matters, I think they would go to court because it's cheaper than doing an arbitration. Arbitration is, they got to file an arbitration. If they win, they get an award. Then they got to go to court to get a judgment. They got to file another file. It makes no sense. It makes absolutely no sense. So anyway, those are
A couple good suggestions there. And the last question I wanted to ask you, some of the concern is, again, the repeat player problem, and that was part of the theme of the New York Times article, is that, you know, that as wonderful a person as you might have, that when you've got these neutrals and they want to work, it's not like it is in a courthouse that you have more than your share of litigants coming in as a judge. But as a neutral, you don't necessarily have that same, I don't know if I call it a luxury or a curse. So how do you address that concern? Again, a lot of this is perception.
I know.
And how do we deal with that, or how would you suggest?
It's, you know, I don't know. I don't know. And no matter what I say, that the people are just the top, honest, best there are, fine. You know, that's not going to persuade the public. The fact that we look at every clause, I mean, the perception, and if I said that really, in my opinion, that the currying the favor of the plaintiff bar is a far more, I think, more delicate issue for arbitrators and mediators, because that's where a lot of the business comes from. And if you run afoul of that group, then your business will decline, and I can give you a lot of of demonstrable examples. So it's an issue that is there, and we just have to, we talk about it, and we say we just have to rise above it and continue to do the best job we can and be as transparent as we can, and, you know, I have no, I'm sorry, I have no easy answer.
Much appreciated. We're going to go to our next panelist, if you can stay, and so there might be questions, but if you feel you have to leave, we thank you for your
Say
time.
a little bit.
Okay, great. So let's go now to Heather Anderson, who is the supervising attorney with the Judicial Council of California. Again, we're talking about arbitrator ethics and issues relating to the appearance of bias or unfairness in arbitrations. Thank you.